Good evening and welcome to the thorough newspaper analysis for 4th April 2022. For the first article today, we have a far-reaching verdict that ends a regressive exception, which has been taken from the Hindu editorial and has been authored by Jayana Kothari. This article talks about the regressive practice of marital rape and how as an exception it has done more harm than good. And for the second article today, we have reforming death penalty, which has again been taken from the Indian Express editorial and has been authored by Anup Surendranath, which talks about the Bachan Singh framework that the Supreme Court laid down when it protected the practice of death penalty, and how the lower courts, including the high courts, have deviated from the Bachan Singh framework while pronouncing death penalties. Following that, we will have the news update and the legal news, which are a part of LawSikho's initiative to keep its readers and students updated with the current affairs happening in and around India. So for the first case today, a far-reaching verdict that ends a regressive exception, that is Section 375 of the Indian Penal Code. The Karnataka High Court pronounced an end to marital rape exception, marking the end of a very regressive exception. The question of the constitutionality of Section 375 had actually gripped Delhi High Court earlier, but the court is yet to pronounce their verdict on the same. While Karnataka High Court, after getting asked the same question, they set straight a regressive practice in one fell swoop. So what happened in this particular case is that a woman was being tortured. She was being repeatedly sexually assaulted by her husband, and unable to bear any longer, she went to the police and lodged a complaint. So when the police heard of this, irrespective of in spite of knowing that the person who was torturing her was her husband, the police went forward and lodged a complaint under Section 376 of the IPC. So when this was intimated to the husband proceeded to quash the charges against him under the marital rape exception. However, the sessions judge declined his request on learning the nature of the assault that had been done on the wife, and hence the order was challenged in High Court because the husband was now aggrieved. The High Court held that the accused was guilty, stating that the exception of Section 375 of IPC is in fact a denial to the equal status of women guaranteed and enshrined under the Indian Constitution. The Indian Constitution gives women the right to life with dignity, personal liberty, bodily integrity, sexual autonomy, right to reproductive choices, right to privacy, right to freedom of speech, and the exemption claimed by the husband of marital rape only serves to undermine these rights and further the commission of crime. The Karnataka High Court celebratedly said that an act of force is an act of force. Hence, a rape is a rape. It doesn't matter whether the man who is committing the same on the woman is her husband or not. The precursor to this judgment can be found in the 2017 verdict by SC in the Independent Thought versus Union of India, where the court held that a wife did have the right to deny sexual intercourse with her husband, and the human rights of a girl child existed whether she was married or not. So we have this concept that when a woman marries a man, the woman becomes the belonging of the man. So this was challenged in the case of Independent Thought versus Union of India, and the Supreme Court strictly criticized this notion and said that just because a wife had married the husband, that did not entitle the husband to have a sexual intercourse with the wife whenever they wanted. The wife could reserve the right to deny sexual intercourse with the husband if she felt so. The marital rape exception, however, persisted, and this exception actually draws its inspiration from the common law system, where a husband could not be held guilty of raping the wife because, after all, it was the wife who had married and the wife had submitted herself to the husband. So this stance was also abolished in the case R versus R back in 1991, when the House of the Lords held that this exception of marital rape did not even closely describe the condition of the wife, and it was thus the court's duty to set straight such laws. For the second article today, we have the reforming death penalty. So ever since September 2021, the SC has been repeatedly raising an alarm regarding how the lower courts have carried out death sentences with very little relevant information. The benches of the Supreme Court have finally taken matters into their own hands, and they are now actively looking into them in order to correct the errors that have been made. So the court is reforming the procedures by which information necessary in a death penalty case is brought before the courts. And the Supreme Court, by doing this, has actually acknowledged the concerns regarding the practices in which the death penalty was carried out. It was being voiced for a very long time that we have issues with our with how the death penalty system works, and the concerns regarding the same has finally been acknowledged by the apex court of the country. The choice between life and death sentences are outlined in the framework laid down during the Bachan Singh case. So, in the Bachan Singh case, the Supreme Court went forward and defended the need of a death sentence. And yet, while doing so, the Supreme Court laid down some frameworks based on which the courts would decide whether to give a life sentence to the person or whether to give a death sentence to the accused. So, in the framework, it was made clear that life sentence is the default punishment that is to be given. In case of rare special situations, the judge might give a death sentence. And this framework is inaccurately and popularly known what we call as the rarest of the rare framework. However, the SC has lamented that often the Bachan Singh framework, which it laid down during the Bachan Singh case, is not adhered to. And this was echoed in the 262nd report, which was a Law Commission report. Project 39A, which is which are a group of lawyers who specifically work with convicts who are on their death rows, they have put forward studies which shows that the framework, the Bachan Singh framework, has been broken down into several small and inconsistent meanings. And this is because, firstly, the people who are on their death row, they are people from vulnerable communities. They belong to vulnerable communities, and they are from the economically downtrodden section. So they do not have the proper money to get good lawyers, and hence they are very acutely misrepresented in court. Secondly, very sparse sentencing information is brought forward before the judges. The Bachan Singh framework is solely emphasizing on the presence of this type of information so that the judge can make an informed decision. And further, this has somehow come down to the point where the courts have now been frequently discussing the admission of mitigating pleas or mitigating factors. And there is no legal basis for the court to do the same. Because it is the tenet of the criminal law that when a sentence is being awarded, it has to be humanized and it has to be tailored to fit individual circumstances. And the idea of mitigation is to give practical considerations of culpability and deservedness that are crucial to the moral idea of punishment. In order to effect that, we will have to start asking questions: what does fairness and individualized justice require in death penalty cases? In fact, the paths of reforming death penalty on one hand and the path of abolishing death penalty on the other hand are not so different. And the more one acts in engaging to reform the system of the death penalty, it only further serves to bring to light why the practice remains to be very unfair. For news updates today, we have one: Pakistan's National Assembly dissolved. Pakistan's president has dissolved the National Assembly on the advice of the Prime Minister Imran Khan. The Deputy Speaker declared the motion for no confidence vote against Khan unconstitutional and it is a part of a plot by foreign powers to interfere in Pakistan's democracy. The opposition, which was hoping to unseat Prime Minister Khan, has cried foul. Opposition leader Bilawal Bhutto Zardari says that they will petition the Supreme Court against the move. For the second article today, we have UN chief names as Indian in climate team. Arunabha Ghosh, who is the CEO of a Delhi-based council for energy, environment, and water, has been appointed as the member of a group being constituted by the Secretary General of UN, which is in essence a climate team. He's one of the 3 Asians to have been inducted in the team and the only South Asian to have received the honor. Australia win ICC Women's World Cup. Australia were crowned the winners of the 2022 ICC Women's World Cup, winning their 7th title. The bowlers did a splendid job to bowl England out for 285 despite an impressive century by Nat Skiver. Earlier, Alsa Healy's sensational 170 had helped Australia to score a mammoth 356 for 5. Megan Schutt gave Australia their perfect start in their defense of 357 in the final, bowling an absolute peach of a delivery. The in-swinger was too good for Danny Watt as she was bowled for just 4. For the fourth article today, we have NCW launched an anti-trafficking cell. The National Commission for Women, better known as NCW, on Saturday launched an anti-human trafficking cell. The facility will raise awareness among law enforcement officials and promote capacity building. It will also conduct gender sensitization training workshops for police officials and prosecutors at the regional, state, and district level. For the legal news today, we have first article, can't appreciate the approach of High Court in rejecting bail in a single sentence, says SC. The Supreme Court has now expressed grave concerns regarding Allahabad High Court's habit of rejecting bail applications solely because the appeal itself should be heard. The Supreme Court has concurred that this has only increased the amount of burgeoning pendency of cases, and this does not help anyone. This approach by the High Court further not only overburdens the apex court, but it is also affecting the accused. And this has been stated in the case of Brijesh Kumar Ramu versus State of Uttar Pradesh, SLP CRL number 1378 of 2022. Secondly, we have High Court can exercise inherent jurisdiction under Section 482 CrPC to modify bail conditions. Section 362 CrPC is not a bar for the same, and this has been held by Madhya Pradesh High Court. The Madhya Pradesh High Court recently amended a condition for bail of two persons accused in a tax evasion case. Had they got the bail, this would have allowed their international travel for the furtherance of their business. However, the court opined that since there were no specific provisions to amend the conditions of the bail given under Section 439A1 of CrPC, the court could invoke the inherent powers given to it under Section 482 of CrPC, and the same has been founded in the case of Jagdish Arora and another versus the Union of India. So this was all for today. For free study materials and TNA PDF slides, you can always join our Telegram channel by scanning the QR code given on the screen. You can also follow us on our official Instagram channels, LawSikho.judiciary, LawSikho CLAT Prep, UGCnet_LawSikho, and LawSikho Law Finance. For any other information, please feel free visit www.lawsikho.com. Thank you.